proceedings. And now she also has a very interesting copyright file that's going on right now. Acts for clients in a wide range of industries and areas. Member of the Intellectual Property Institute of Canada and sits in their committees. Is also a member of the Advocate Society. So please join me in welcoming Jill.
Thank you, Trent. Okay, so let me learn how to use this remote control. There we go. You have a great product and you have a great service. How do you present your product and service to your customers and potential customers? And how will your customers know that these products and services come from you? It's all about branding, and branding is the face of your business, your product, and services. Coca-Cola, IBM, Microsoft, Google, GE, McDonald's, Intel, Apple, Disney, HP. We all recognize these brands. And not surprising because these brands were ranked as the top 10 brands in 2011 by Interbrand. Brands have value, and let's just take a look at what the Coca-Cola brand is valued at. $71 billion. IBM, this brand is valued at almost $70 billion. Microsoft, $60 billion. Google, almost 55. GE, 42. And McDonald's, Intel, Apple, Disney, and HP, they're all in the $30 billion range. So brands have value. And these owners, the owners of these brands have invested money and resources in creating, protecting, and managing their brands. So my presentation today will focus on strategies for brand creation, protection, and management, some things you need to consider in putting a face to your products and services. In creating your brand, be choosy, be careful, beware, and think of where. These are some things you should consider. Be choosy. Not everything can be registered as a trademark. Dominique has already gone through some questions that you should consider in choosing a trademark. And I think a very basic example is, if you sell chairs, you will not get a trademark for the word chair. So as Dominique has already gone through these questions, I think it is still important and worth repeating here because it is the starting point. You don't want to invest money in promoting a brand that you cannot obtain the trademark rights for. So ask yourself, does your trademark describe your products and services? So if you're making chairs, the word chair would not be a good trademark. Would it also deceive someone in thinking about the quality of your products and services? So Pure Cow for us, the almond beverage, is it clearly misdescriptive? Is it deceptively misdescriptive? Does your trademark contain the name of a place that is commonly known to be the place of origin of your products or services? And Dominique's example was Seville for oranges. And this is my favorite example, and Dominique's already given this, gelato for ice cream. Is your trademark the name of the products or service in another language? Is your trademark just really known to be a name or a surname? Is your trademark a purely functional aspect of the product? And are you aware of any other similar names out there in the marketplace for similar wares and services? If you answer yes to these questions, start over. Don't fall in love with this brand. Start from scratch. You want to avoid problems down the road in obtaining trademark rights and enforcing these rights. So up front, avoid any problems down the road by being choosy. And ask yourself these questions, because not everything can be registered as a trademark. Be careful. Snoop first. Why? Because rights and trademarks come from use. you want to suss out the lay of the land and make sure that no one has already taken this mark. Make sure it's available for use before you pour all this money in promoting your brand and services, products and services under this brand. And how do you do that? Well, first I would simply go on the internet and do some searches and see if anything comes up. But there are certain legal issues that you need to consider. For example, use is a defined term under the Trademarks Act, so it may not necessarily be trademark use and may be available. So you really need to take a critical look at whether or not something's available. So while you can go on the internet and poke around and see what's out there or see if anything's out there, you also want to do a more thorough search, a trademark clearance search. And you do that by hopefully getting help from experienced counsel. And these searches will cover trademarks, trade names, domain names, and trade directories, and common law uses. And domain names, that's an important search to conduct, because from a business perspective, if you are wanting to promote a particular brand, you would likely also want to get that domain name. So if it's already taken as a domain name, think about whether or not it's worth investing money in that brand when you may not get the domain name. So it's a big picture approach, but you want to snoop around and make sure that the trademark is available before you come to a landing on this brand and spend money investing in promoting this brand. Beware. Look out for something called Section 9 marks. Under the Trademarks Act, there's a list, and under Section 9, not surprisingly, there's a list of things that you cannot use, and these are prohibited marks. So the example would be the Red Cross emblem, the RCMP. And under the Section 9, there's a specific category for marks that have been adopted by public authorities. These marks are a little dangerous, and you should watch out for them because they are perpetual in nature and not tied to any particular wares and services. And they actually don't get registered. So if you're poking around the trademark database online, you'll see that it's advertised but not registered. They don't get registered, they get advertised. And this public notice to, the public of this adoption of use is enough to stop all subsequent users from adopting that mark. So beware and look out for Section 9 marks. And included under Section 9 are words that would be considered immoral and obscene, and some of that is quite intuitive. And where. So you've done your due diligence, you've snooped around, it looks like it's a mark that is not the name of someone and is distinctive, but think about where you intend to offer your products and services. If it's not just Canada, it could be the US, it could be in Asia, India, China, in Europe. Make sure your mark is available in those countries as well. You don't want to start pouring money investing in a brand that's available for use here and then have to consider a different brand in a different country. We all recognize Coca-Cola, it doesn't matter if you're in India or China or Canada, you recognize that mark, it's consistent. So make sure that your brand is available for use in all countries that you intend to launch your products and services. So you now have a brand, it appears to be available for use in the countries that you're interested in operating. What's next? Well, let's focus on strategies for protecting and managing your brand. And there are 4 things you should consider. Register your trademark. Build up your trademark portfolio. Use it or lose it, and enforce it. Register your trademark. Dominique has already gone through some of the benefits. You know you don't have to, but you should. And we've given you some reasons why you should. For example, exclusive rights to use that trademark in Canada. And this is everything that Dominique has already covered. You can keep it forever if you renew it every 15 years for a very small fee. Enhanced remedies for enforcement. But let me give you another reason why you want to register your trademark even though you don't have to. Block them out. The trademark register is publicly available. Simply having your trademark on the register may deter others from adopting your mark. So rather than having to spend the money to enforce, it can be a preventative measure that you can take. Also, without any intervention on your part, the Trademarks Office may rely on your registration to block out any subsequent applications for similar marks from your competitors. So there's an additional benefit to registering your mark even though you don't have to. All the brands that I've just shown you in the beginning of my presentation, those marks are all registered, and not in just one country, but all over the world. Now, things to consider when you're filing for a trademark. Have you used the mark, or do you plan on using the mark? You don't necessarily have to have use of the mark to file for an application. There are different bases to base your application on. So if you've already used the mark, now use is a loaded term, it's defined in the Trademarks Act, then you may file your application based on use and claim the date of first use. Now be careful. Coming up with a name in a board meeting and recording in your minutes is not use of the trademark. So it is important to get everything right in your application so that your application and your trademark registration is not liable for expungement later on. So have you used the mark, and what is use? If you don't know, talk to someone, ask a lawyer. Do you intend to use your mark? Because that's also a basis for filing. So you can actually reserve your trademark without actually having used it in Canada by filing a trademark application. So it can be based on proposed use. Do you already have a foreign registration and are using a different country? So that may also be the basis for filing a trademark application in Canada. What wares and services, what products and services do you tend to use the mark in association with? These wares and services or products have to be defined in ordinary commercial terms. How do you do that? Well, you have to be careful, because if you don't, your application, that may be a basis to oppose your application down the road. And there could be different bases for filing. You don't necessarily have to base it all on use or proposed use. You can put different bases together and really strategize to maximize the value of your trademark application. So there are things to consider up front, and it's important to get the information right. So what's the process? It's not unlike a copyright registration, which can take a couple of days to obtain. You file an application, it gets examined, and you file it with the Office of the Registrar of Trademarks. It gets examined for all of the things that I talked about up front. Is it registrable? Is it confusing within the existing marks or pending marks? Does it conform with the formal requirements? Are the wares and services described in ordinary commercial terms? If everything is fine, it gets advertised in the journal. And this is where any third party can oppose your trademark. So if someone comes along and says, wait a minute, I've been using this mark or something that's similar before these guys have, I'm going to oppose. Again, this comes back to be choosy and be careful up front. Choose something that's going to minimize these types of problems in the registration and enforcement process later on. If no opposition is lodged, or an opposition is lodged and resolved in your favor, the application is allowed, you pay a registration fee, and off you go, you have a registration. Now, if you base your application on proposed use, you do need to file a declaration of use before you can obtain that registration. If you're basing your application on foreign use and registration, you don't necessarily have to have use in Canada. So those are some strategies that you can consider when filing your application, and build it into the timing of the launch of your products and services and what you intend to do in the near future. I just want to touch on oppositions very quickly. I'm mindful that I'm standing between you and dinner, and I have a few minutes left. Oppositions can take years to resolve, and it is like litigation. Pleadings are exchanged, there's evidence, cross-examination takes place, and there's a hearing. It's not inexpensive. And so again, we go back to the first point, be choosy and be careful, do your due diligence. Choose something that's not going to give you problems down the road. Now that said, your competitor may oppose for frivolous reasons, and so you may be in a position where you have to defend your trademark on various grounds. So you have your trademark registration, what's next? Well, you should really think about building your trademark portfolio. And some things to ask yourself are you using new brands? If so, think about obtaining additional trademark registrations. Have you expanded the use of your brand? So you've obtained a trademark registration that covers apples, and now you're selling other things like chairs. Well, think about extending the coverage of your registration to cover new products and services. Have you changed the look of your brand? It may not be necessary to obtain additional registrations for modifications. It really depends on what you've changed. But that's something you need to consider. Have I slimmed down my penguin? And that's a famous case involving the use of a modified version of the penguin that you see on shirts. So he was quite fat in the 40s, and now he's slimmed down, and so is that use of the mark as registered. And in the court held that it was in that particular case. So you have to watch out when you're modifying your registered trademark. Is that still use of the trademark that you've registered for, or do you need a new registration? So the bottom line here is be mindful of how your business is evolving, and make sure you stay on top of your trademark portfolio, and so that it matches and covers what your business is, where your business is headed. Use it or lose it. We've already talked about how important it is to use your trademark and that rights come from use. After 3 years following registration, any third party can start up something called a cancellation proceeding. And all you have to do is write a letter to the registrar of trademarks and ask them to issue a notice so that the registrant has to demonstrate or file evidence showing use of their trademark. So getting a registration is not the end game. You have to make sure you use it in order to maintain it. So it's important to review your portfolio and say, have we used these marks lately? And if not, use it. And if you don't care about it, that's another thing. But if you do, make sure you're using it. And finally, enforce it. I just want to make 2 points here. It is your responsibility as the owner of your trademarks to ensure that others are not infringing on their rights. So police the marketplace and take legal action where necessary. Write demand letters, but it's up to you to stop others from infringing upon your rights. Second, one problem with being successful and having a well-known trademark is that the term may become a generic term, and when that happens, the mark is no longer distinctive of your products and services and no longer functions as a trademark. Did you know that zipper used to be a trademark, but now is used to describe all sliding fastenings, and same with escalators? So those are some things to think about in terms of creating, protecting, and managing your brand. Any questions? Yes?
Could you give us the ranking of the brand? Where is the data information source?
It comes from an organization called Interbrand.
Interbrand.
Yes, so if you do a Google search Interbrand, they have rankings every year, and it's the top 100 brands. Yes?
How do you actually measure the brand value, or actually like in numbers? Is there any particular way, any idea regarding that? Because like I had a brand value, branding management class, but never got to that point. Like, okay, how do they actually measure the value?
That's a good question. I certainly don't know how to value a brand. I know that brands have a value. I think different companies provide those specific services. If you go onto the Interbrand website, they may show how they've actually conducted the evaluation. Yes?
When registering a brand name, I understand that it can be based on place of origin, or the origins. How can we trademark just the acronym, like FLO, just knowing that it implies Florida origins?
It really depends, first of all, what's already out there and the examiner you get at the trademarks office. So there's certain arguments that can be made that it's not, that it's registerable and doesn't contravene that particular provision in the Trademarks Act, but it really is something that you need to consider on a case-by-case basis, and it's important to look at what's already out there.
Gina, thank you for wonderful presentation, and thank you for having us.